Bill Henshaw here again, another of my series of videos on current events. And this one is number 2 with regard to documents available in my modestly priced constitutional defense document packet. You can get information on those. Send me an email, youwinincourt@gmail.com. This one is the conditional acceptance of counsel. And it's an important one for more than one reason. I've had just about a 180 reversal on this issue, and that doesn't come easily to someone in his 5th decade of research and 15th year all in against these bastards. But I understood after thinking about it that this is a better approach, because in South Carolina, when I was sitting there 5 months in jail as a political prisoner and 2 months back here, I didn't accept counsel. They appointed a liaison counsel for me, a story for another video, but I never accepted counsel on the record. I might now, because this conditional acceptance is different, because I was saying denial of counsel, since that's the situation. We don't have counsel because state attorneys, bar association attorneys, aren't going to help us, even if they know the law, and most of them are egregiously ignorant in this area. They're not going to do it because they have irreconcilable conflicts with both the Constitution and our rights secured by the Constitution. The conditional acceptance, however, notes the real relationship that should exist between victims of the just us system and the damn state bar association attorneys, which is principal and agent, not master and slave the way they see it for those who owe their birthright citizenship to the 14th Amendment. It's a big change in perspective, and it is. So we're saying, in effect, okay, we'll accept counsel, but principal and agent, we tell counsel what to do, not the other way around. And that's a big deal because, if we don't get that condition, then we don't accept counsel. But at the same time, even the 9 old farts are going to have a hell of a hard time saying in our case that we've made a voluntary, knowing, and intelligent waiver of the only right the bastards think we have. And this is them saying it, not me. Case of Johnson v. Zerbst, 304 U.S. 458. Voluntary, knowing, and intelligent waiver. We did all we could. But counsel wouldn't do the job. They wouldn't do what we wanted. So we're left to our own devices, never having been educated in their mandatory public education system. So we don't know our rights. We don't know what the hell is going on in these courts, what courts they are, where they are, the rules of the game, nothing. And as I said with my video on the bill of particulars, the same question comes up here. Why the hell bother to have a trial? Doesn't make any sense. Just go to the directed verdict of guilt and get it over with. And you'll notice these courts have a 98+% quote unquote conviction rate, AKA as a directed verdict of guilt, and that's all they specialize in. You show up, you get convicted. It's only a little better than another system that existed earlier in the 20th century, where you could actually show up and get shot and killed within a day or two after admitting your guilt. And that's the system that was run by good old Uncle Joe Stalin. And I think today, any of his surviving relatives, and I know his daughter has passed away, Svetlana Aliyeva, but they would have a hell of a claim for patent infringement in any court in the United States on what's going on here. I mean, it's that bad. And how the hell did we get here? Where is the consent of the governed? They may actually have mentioned that to you when you were in junior high school and high school. I do recall, I think once or twice we heard that, but trying to find it in this system, good luck with that. It ain't there. How are they doing it? On what authority? We have every right to ask questions like this, and they have the sworn duty to be bound by this Constitution and laws enacted in pursuance thereof. And they're the ones that they have to answer questions, and they don't have any answers. So when you show up in their courtrooms, and especially if the black robe bastard gets very derisive, dismissive, and things like that, and angry at you, you're on the right track, because they know perhaps not to the fullest extent they should know it. But if we're right and they're wrong, they're acting unofficially. They have personal liability. They don't have any immunity at all, even qualified immunity. And I know the case law in that area a hell of a lot better than they do too. That's the real bottom line. We can make them pay for it. How many of those Black World Badgers you suppose have to be sent out there to jail, maybe even San Quentin for a good spell, and before people get the message? I mean, that's a game changer. Because once they realize that we have them dead to rights, and we're the ones that have the power and they don't, that changes the whole ballgame. It starts to put our system back on the track to get where we were. And just a quickie here on that, yes, that goes back prior to the war between the states. And yes, I can be easily confused, with a white supremacist. But those are the arguments that win. Nation and Republic, free white male 21 out in California. We have a case that says that called, I'll think of it here in a minute, 43 Cal 43, and they rule it in there. Article 2, Section 1 sets forth who the people of the state of California are. It's Van Valkenburg v. Brown, 43 Cal 43, in conjunction with Scott v. Sandford, that infamous Dred Scott case that the only thing you heard about in school, like I did, was that Roger Bructani, perhaps the best justice of all time, said in this opinion, and he said word for word, that a black man has no rights the white man is bound to respect. What they didn't tell you was the context that arose in. He was talking about the time period in the 1770s, back when we were still colonies. Why it's infamous, and I said it in the earlier video too, is they don't want you to know that in territories, Congress is limited in powers there too. They don't think so. I think they think they're actually insular territories like Guam and Puerto Rico and the Philippines used to be at one time. Territories that had no possibility of becoming states at all, which is a little bit different situation. There's a whole spate of things called insular cases that the Supreme Court decided in the early 1900s to talk about this subject matter. If that's where they think we are, it's even a better question. We not only got relegated to a territory, but an insular territory. And they've not even attempted to answer either of those questions, and they won't, because there's no answer to it. If they're going to say the 14th Amendment, the brief you get in my document packets, by the way, send me an email, uwinandcourt@gmail.com, absolutely destroys the 14th Amendment. It never existed from day one, violated all 6 articles of the Constitution, what I at times call a gargantuan, grotesque, grisly grand slam of violations of all 6 articles. Never existed from day one, yet it's never been challenged in 150 years. A subject matter for another video, and we're going to be changing that, and maybe in the process right now. So this conditional acceptance is a big deal. You say, fine, I'll accept counsel, but I make the rules, you don't. And with the Supreme Court having ruled in Argersinger v. Hamlin, Sheriff 407 U.S. 25, page 40, that let each judge know at the start of a misdemeanor trial, no jail time can be imposed though local law permits it, unless the accused was represented at trial. Now, even if they get a conviction, they can't send you to jail. They can't fine you because they can't define dollar. And I've paid not a damn red cent in 5 decades, fines, fees, anything else, you name it. Early on, they probably assumed I was going to make that argument. I didn't know it right at the beginning. And a lot of you won't know when you start out either, but you read my documents, you'll get it. Nowadays, I routinely do that. And since they can't answer it, I sent a letter to the DA out here a number of years ago and said, please, charge me with a willful failure to pay a traffic fine. 18 years later, I'm still waiting. Not going to happen because they can't define dollar. A really interesting video coming up on that one too. In the meantime, send me an email for information, uwinandcourt@gmail.com. Like the video, subscribe, tell your friends. We have an unprecedented window of opportunity to beat these bastards. For the next several months, and with the COVID vaccine coming out, a lot of people are going to be real interested in protecting their children. If they don't do anything else, they'll fight that one. So a great window of opportunity for us to act. Email me, uwinandcourt@gmail.com. See you in the next video. Thank you.